All right, the next case on the docket, Jennifer BURNO versus Donald BURNO.
Good morning, Your Honor. May it please the Court.
Okay.
My name's Jessie Harrell. I am with the firm of Creed & Gowdy, and I'm here on behalf of Jennifer BURNO. I'd like to take the opportunity to reserve 5 minutes of my time for rebuttal. What I'm here asking for today on behalf of Ms. BURNO is that you reverse the partial final judgment of the trial court that modified the custody during the school year, where Ms. BURNO was the primary residential parent and Mr. BURNO rotated his visitation on the weekends to a rotation of month to month.
There are two witnesses that testify during the totality of this trial, correct?
Correct, Your Honor.
So when we look at this for purposes of appeal, we look at it in the light of really most favorable to the appellee in terms of the evidence.
You do, Your Honor, but really you have to consider what the trial court found was the substantial...
Well, you know, and there's a little, well, I have a little bit of a problem with that, you know, in that the oral findings that were made were not reflected completely within the final judgment prepared by the wife's counsel. I realize you were not counsel for the wife below. But we've got some oral findings that, you know, I think we also have to consider that did not make it into the final judgment. I recognize that the trial court bears the ultimate responsibility of ensuring the accurateness of the judgment. But, from my perspective, I'm looking at it both in terms of the written final judgment and the oral rulings that were made, and perhaps, you know, that is something that we're going to need to address. But given that framework, don't we look at this and accept effectively the former husband's testimony as to the circumstances that existed?
I still think we have to look at specifically what the trial court said in its final judgment.
Well, and I've just told you that I'm going to look at the oral rulings that were made at the conclusion of the trial because for whatever reason, the trial judge allowed the party that you would have to deem as the probably the losing party below and let them prepare the final judgment, which is never a good idea, but that's what the trial court judge did.
To me, it reminded me of in a contract interpretation situation, you interpret the contract to, you know, against the drafter in some respects. So I think that we need to look at it more broadly than just what the mother's attorney may have drafted in their own interest as to what the total oral pronouncement of the trial court was.
And I think we look, or at least my concern was the two things that were definitely withheld from the written order as it was drafted by your client was that the mother had withheld weekend visitations and the allegation that the mother misrepresented a law enforcement in an effort to deprive the father of some of his visitation time with the children. So that's not insignificant. It's not like it was just something that the court brushed over. That became a focus of the hearings and the trial, and ultimately the order that the judge orally pronounced. The fact that it was not included in the written order is a shame. If we were up here and had reviewed that written order as fully listed or itemized by the judge orally, maybe a different situation entirely. So it was not insignificant, you would agree?
I would agree that is not insignificant, no.
All right, so taking that into consideration,
Okay.
You know, let me hear your argument in terms of why, given all of that, there's reversible error in this case.
There's still reversible error in this case, Your Honor, because I'm sorry. You have to look at how
I think your argument would be that even given the evidence presented to the judge, that there was not a substantial change in circumstances.
I would, Your Honor. If you look at the original second amended final judgment, that court said that the original trial court, Judge Pope, said that the mother was not the party who was the most likely to foster the contact between the parties. And Judge Tekak, who was the second judge, said, unfortunately, that has borne out to be true. But that doesn't make it a substantial change in circumstances. It was recognized at the time of the second amended final judgment that the mother wasn't the best equipped to foster that relationship, and yet based on all the other factors.
Does that mean that she gets a walk on, on that issue, that she never has to make any attempt because it was recognized at the time of the original final judgment that she might not be very good at it, so she gets a walk?
No, Your Honor, I'm not saying that she gets a walk, but we have to look at, under the Wade versus Hirschman standard, whether it was an unanticipated change in circumstances. And I appreciate she has to comply.
Well, how would you, distinguish, the Knipe case, out of the fourth where, I'm not sure who wrote that opinion, but they talk about the purposes of the shared parental responsibility, and they really talk about it in terms of looking down the line and seeing how the parties have complied with the terms of the order. And that's one of the functions and one of the goals of the whole statutory concept. So it's a little disturbing to me that you would make the argument that because the judge recognized at the time of the original order that she isn't any good at this, that's it. She never really has to even put an effort out because it's not unknown.
No, Your Honor, I think that's carrying it a little extreme of what I'm saying, but I think Knipe is very distinguishable. There, the Fourth District said that where the mechanics get stuck because of gross misbehavior of the parents and the children are suffering, the court can fine-tune the judgment. And the Knipe case specifically distinguished cases that modified custody. What the Knipe court did is it said the parents are so incapable of communicating, we're going to give the mother a Monday drop-off at the school so that she never has to see the father. We're going to give her a little bit more time. It tweaked the judgment so that the mother's visitation increased. It did not modify custody, and it specifically distinguished cases that modified custody. And so...
Of course, we don't use the concept of custody anymore.
Right. It is sort of a shorthand that even the courts are still using post changes in the statutory, primary responsibility and secondary responsibility. But the fact is you aren't supposed to modify unless you have the substantial material unanticipated change of circumstances and the best interest.
Given that we've told you that we're looking at the whole oral announcement of the court and not just what was written for purposes of argument's sake, should we also take into effect that the trial court, after hearing all the testimony, said that the dispute sounded petty and minuscule?
Absolutely, Your Honor, and I think that's really the crutch of what this case comes down to. Can you ever have a substantial and material change of circumstances over complaints that the trial court said were petty and minuscule?
But the judge did in the final judgment say that there was a substantial, easy for him to say, change in circumstances. So the trial judge did make that finding in the final judgment.
In the partial final judgment, yes, he did, and our position is that the reasons identified in that judgment, as opposed to the oral pronouncement, are legally insufficient, because he looked at the best interests within It appears that the trial court confused the best interest with the substantial material unanticipated change in circumstances by saying if the children's best interests aren't being served, then you have the substantial change in circumstances, and that's not the law. Wade teaches that you have to have substantial material unanticipated change in circumstances in order to overcome the res judicata effect of the prior judgment.
You
And
can understand that the
Okay.
trial judge, and as well as we would be, disturbed by the fact that the mother in this case lied to law enforcement to effectively cheat the father out of time with one of the daughters. Is that not disturbing to you?
Your Honor, I'm not clear that she lied to law enforcement. I mean, I just don't recall from the record. I mean, he brought the law enforcement there. She said she wanted both the girls back for school to start. One daughter's school was starting, the other one was not starting yet.
Well, I think the judge was being kind in saying the mother misrepresented to law enforcement. I think that is code for the mother lied. You have an independent, neutral observer coming in as law enforcement, and the mother is putting the law enforcement officer in the middle of obviously a very volatile situation, and using the law enforcement officer and their show of authority to effect a denial of the father the right to have that visitation. So you want to say misrepresentation, you want to say lie. To me, in this circumstance, with a law enforcement officer not knowing who to believe, I believe it's correct. It was a lie. It was very dishonest.
assuming that to be so, which,
Okay.
why isn't that part and parcel of a substantial change in circumstances when you have a mother who is not following the terms of the final judgment, is being obstreperous to deal with, scheduling things during his time, not allowing, because I'm looking at this evidence in the light most favorable to the non-moving party here. That's what his testimony was. Why isn't that a substantial change in circumstances?
Your Honor, I think if you look at that one incident where she misrepresented to the police officers, are we going to say that a parent, and it was less than exemplary conduct, I will concede that, but are we going to say that a parent loses their custody, for lack of a better word, over one event that...
But it's not one event. You've got a number of, the testimony was replete with circumstances where she had scheduled something during his visitation time. He complains about it. He goes to pick the children up during his visitation time, and they're not there. It's not one instance. You're familiar with the record. It's replete with incident after incident after incident. If it was one time, I don't think we'd be here. I don't think the trial judge would have done this if it was just one incident.
Your Honor, based on if you look at the record and the comments that the trial court made, it appeared that he said, what I'm hearing is that everybody wants the father to be more involved, and I haven't, a sharing of these responsibilities, and I haven't seen any evidence to counteract that. And then he goes through and he says, there's not enough involvement for the father in the lives of these children. The Lake County visitation is not furthering. It's antiquated, and it's not giving the opportunity for both parents to be involved with these children.
Didn't she change schools, the children's schools, without notifying the father? Was there record evidence to support that?
He did testify that she had done that early on.
And it wasn't just, as I remember the record, it was from Lake County to Brevard County, correct?
Well, that was prior to entry of the second amended final judgment, Your Honor, that the court required her...
She moved 35 miles away from where she had been, correct?
To where she relocated within Lake County?
She moved 35 miles away from, as I understood, from where the former husband was living. Is that incorrect?
I think I'm not sure if you're talking about when she moved to Brevard or when she moved back to Lake County, because in the second amended final judgment, she was required to move back to Lake County in order to be the primary residential parent.
I think there were a couple moves of the children. There was the initial move after the proceeding was filed, I believe, in, March of 2005, and the final judgment was entered in 2006, and that was when she moved to Brevard County. But wasn't there a subsequent change of schools within Brevard County, and the father went with like 2.5, 3 months without knowing the new schools that his children were at?
Yes, Your Honor, there was testimony as to that, although he also testified that the schooling was no longer a problem now, and he had the ability to keep himself informed. And the case law is abundant that where the parents have the opportunity to keep themselves informed about the schooling, that the breakdown in communication isn't sufficient to modify custody. And I'd like
No,
to
but I
reserve-
think what we're addressing was your comment that it was an isolated incident. And I think what we're pointing out is that it appears from this record that there were a number of incidents. Yeah.
What I was saying is that is the most egregious incident, and yes, there were a number of complaints, but if you look at where the parties are right now and not what has happened over the past 6 years, the father testified that he has a good relationship with these girls, that he's involved in their schools, that he keeps in contact with their schools, that most of the problems that he has complained of in the past 6 years have resolved by
Right.
this point.
If the trial judge applied the correct law, what is the standard of review?
Abuse of discretion.
Right. And your position is that he did not apply the correct standard of law?
That is correct.
Okay, that he did not, even though the judgment says that there's a substantial change in circumstances, you think nonetheless that the trial judge looked at the best interest?
That is correct,
Right.
Your Honor.
Right. You're within your rebuttal time. Would you like to reserve?
I would like to say that.
All right.
Thank you, Your Honor.
Okay. Give me just a second here.
Good morning. May it please the court, Julia
All right.
Graves on behalf of Donald BURNO, the former husband in Appalachia. As far as this particular case, I think that the argument that's been made on the appeal that the judge absolutely reversed custody is not really a fair argument as to what was done here in the final judgment. I believe what the judge did was adjusted the schedule. If he was going to reverse the custody, he would have taken what the mother had and given it to the father and given her every other weekend and reversed it.
Well, but
and taken away.
they went from, having one time-sharing arrangement to effectively having rotating custody.
Correct, and that gave the father approximately...
So call it, we're stuck with the fact that the legislature, keeps changing this nomenclature, every few years.
I
But
understand.
call it what you want to call it. The children were spending the majority of the time with the mother before this, and now they're not. Now it's effectively 50-50, right?
Right, correct, it is
Okay.
effectively an equal time sharing.
And you don't think that's a substantial change?
I believe it is a substantial change, but it's not a reversal of what is being argued in the appeal. A reversal would be changing and taking so much away from the mother. There was time taken away from the mother, but it really was only 80 days difference if you add up the calendar and change from the time that the father had.
That's a lot.
It's a lot. It's a lot, but it's not taking a major, not taking it all away from the mother and giving it to the father. Where what the court did was take the part of the order that there was no complaints about, which was the summertime where they alternated the time, and that's what was working for the parties without any argument and applied it to the whole year.
All right, but let's talk about whether the judge applied the correct standard. This is, when you read the record on this, some of the comments that he made seem to indicate that he perhaps did not apply the right standard. That he talks about really that this is kind of no big deal.
I
And
understand.
then how do you go from, this is minuscule to there's a substantial change in circumstances?
I think that the record reflects the judge's frustration with these two parties, and although if you look, and I believe that petty and minuscule was probably a very poor term to use in this type of a situation where you're going to substantially modify the time-sharing arrangement, which he did. But I think that on a daily basis, each time that the father would show up and the children wouldn't be there, maybe one time that would be petty and minuscule, but I think that what it's improperly termed in the final judgment in his comments is that added up over time, all of the situations over the time period where the father was not given time with the children, although petty and minuscule on that particular day, it added up to a substantial change in circumstances. And as you
and there are other times where he really seems to be talking about best interest of the children, which would not be the standard.
Correct. I believe that, and you all mentioned it, that, you know, in the first, the order that's being modified, it was recognized that the mother was not the parent that was going to promote the relationship. But I believe the original final judgment anticipated, and you can read into it whatever you want to read into it, but that because she's being given a second chance, that would change, and that she would promote the relationship because she was being given the majority of the time with the children. But instead of changing and working with that she was given, she withheld time from the father. She didn't promote the relationship. He was given reasonable visitation at all other times, and there was never, ever any other time. Not only was there never any other time, he wasn't even allowed to use the amount of time that he was given. It was kept from him. So based on that, I believe it's a substantial change in circumstances that even given the second chance to redeem herself, she did not. She kept time from him. She never agreed to any time during the week, and this father is being substantially kept from his children and participating with them during the week. He was never given any time during the school year.
What evidence was there that this was in the best interest of the children? Assuming that you meet the first, that there's a substantial change in circumstances, what evidence was there then that the change would be in the best interest of the
I
children?
believe the evidence would be partly back what I said before, that there was no conflict and argument during the summer when the time was set out and they alternated it. It would be in the best interest of the children for there not to be arguments or the father calling to find out where the children are, and the mother hiding the children or putting the children in some activity.
Excuse me, but was there any evidence from an expert or even testimony from the children that would support the trial court's finding that it was not in the best interest of the children?
There was nothing, I'm sorry, that it was not in the best
That
interest?
it was in the best interest.
That it was in the best interest,
of the children.
or that the current arrangement was not in the best interest of the children?
I believe that the court wanted to hear from the children, but
Your client was against it.
he was against it, but the children were not brought there, and I guess, I'm trying to remember exactly from the record what occurred, as I was not the attorney there.
But I think it's fairly clear that your client was the stumbling block with that.
He was not in favor of the children testifying, but there was only two witnesses, the former husband and the former wife, so there was no expert and there was no evidence from the children or testimony from the children. I think the judges had to rely on what the two parties had to say, and I'm sure that each of them would be giving more self-serving statements and their testimony against each other.
So was that legally sufficient? Sorry, Ann.
That's all right.
I believe it's sufficient when the judge was able to make his findings from what they testified to, and I believe that the former wife also, testified that there was no other time sharing during the week, and that the court found that it would be in the best interest of the children for them to have their father participating throughout the year and not just at the control and the demand of the mother.
Just to make sure we finish the discussion about whether or not the children were going to testify, the mother ultimately, at the end of the hearing, offered the testimony of the children, and I think the judge expressed reservation about that, since there was nothing even at that point said by the father as far as whether or not the children would testify. Is that correct?
That's correct. And I don't know how far away it was to go get the children, or whether the court was willing to give them any more time at that point. I believe they kind of ran out of time, and that concluded the testimony for the case, and he made his ruling. And as far as the wanting the father to be more involved, I think that also is something that the court determined was in the best interest of the children. And while everyone testified they wanted the father to be more involved, that wasn't what was happening, and I think the court recognized that.
You think that the best interest standard is a generic standard, or is it individualized to these children? we could say generically, it's always in the best interest of children to have a father involved.
No, I don't think you can say that generically whatsoever, but there was nothing in any testimony by either party that this father's involvement was in any way damaging or that he had anything.
Well, actually, I mean, there was some testimony as to that in the sense that there were times where, you know, an occasion where he didn't take him to school, that he didn't take him to extracurricular activities. I mean, there, you know, it's not like there's no evidence in the record as to that.
I agree there is one or two times that he didn't take them to school. I think he was too sick to drive the distance the one time. Other than that, he's made the effort
Yeah.
to make a long drive from his home to continue the children in the private school that the mother put them in, that he had no idea they were in for a period of time, at least the older child, and then the younger child moved to that school later. But I don't think it's a generic standard that it's always in the best interest of the children, but in this case, the involvement of the father seemed to be in the best interest of the children, and that's what the court found, that his participation was something that was a positive input for the children, and there was nothing that said that he shouldn't be involved with the children.
You know, doesn't the distance involved here and the some of the experience that these parties have had make it appear difficult in terms of extracurricular activities for these kids when they're going back and forth like a ping pong ball?
As far as the extracurricular activities, I believe that my client, the father, was willing to allow the children to do the extracurricular activities, but it seemed like when he was trying to pick the children up, he wasn't told they were in an activity, and so he would have to sit at the school for an hour or an hour and a half before he could pick them up for his weekend, or they might have gone somewhere and not be available. But shared parenting, which didn't seem to be occurring here as far as what activities the children would be involved in, they were never discussed with the father. The mother just unilaterally made decisions. I'm going to put this daughter in this and this daughter in this, and we're going to have some, one in something every single day so that they're not available. It's certainly something that needs to be discussed between both parents and decided upon both parents, so that the parents can actually spend time with the children. You can enroll your children so that they're so busy doing things that they don't have time to do, and spend quality time with their parents.
Was there any evidence presented to the trial court that that was the mother's intent, that she had an ill intent in signing the children up for extracurricular activities for the sole purpose of keeping them away from the father?
That, I believe, was what the father was beginning to believe, and I think there was some evidence that he felt that they were being kept from him by being enrolled in all of these activities that he didn't know about. It's sort of an unusual situation with the schooling where the children are there at a private school on a scholarship, and the mother actually lives in free housing provided by the school. And the father, where they said that the schooling situation had been somewhat resolved, and the father's okay with them continuing, I believe the testimony shows, in that school so long as they stay on the scholarship, but he doesn't have the financial ability to pay for it and keep them there if she loses that scholarship situation and that free housing. So it's sort of an unusual situation with their school. I don't think the testimony ever showed how that actually came about.
All right, anything further?
Nothing further.
Any further questions?
No.
All right.
Counsel, assuming that we agree with your position and decide to reverse, how do we get around the Compton case?
The Compton case. Yes, Your Honor, that was a case that was cited by the defense, and in that case, excuse me. Let me make a note. I wanted to address Compton, and okay. The Compton case said there was overt alienation of the children, and we didn't have any evidence of alienation in this case. We had a father who came in and testified that he had a good relationship with these children. And so Compton is distinguishable in that you don't have a mother who is overtly alienating the affections of the father. The father has been able to maintain a relationship. Even I understand that only 2 of her emails were introduced into evidence, but the one of them from December 24th shows that she was working with the father to try to make arrangements within his schedule. And so there were instances perhaps where she was not accommodating to the father, but in particular with these midweek visitations, that was not something that was required of her in the final judgment. And so if you are taking the 6113 standard that says you can modify where a party refuses to honor the time-sharing schedule, the midweek contact, the telephone contact, none of those things were ordered of her. And so those findings in the final judgment wouldn't be sufficient because she wasn't violating a timeshare through those actions. I also wanted to address, and Your Honors brought it up, but there really was no evidence, not really, there was no evidence that this modification was in the best interests of the children. The father, this being his motion, he had the burden of proof on this. He didn't bring in the children. The mother, as you recognize, the mother asked for rehearing for the court to hear testimony from the children because she was unaware at the time that was something the court wanted to hear, but she believed that it would make a substantial difference in the trial court's opinion if he heard from the girls and as to whether they wanted to have this arrangement with their father, and that was denied her. And the idea that it was in the best interest of these children to have their dad participate more in their lives, it does read generically, and the trial court's opinion or disfavor of the original arrangement and desire to see the father more active in the children's lives really has no place in the judgment. The original judgment has res judicata effect. And I see that my time is concluding. I would ask that you do reverse the partial final judgment. Thank you.
Thank you, Counselor.